And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shaw Pirelli for the Shaw Pirelli Law Show, coming at you with over 50,000 watts of power. The Shaw Pirelli Law Show, where all your views matter.
Hello, everybody. Assalamu alaikum, Sastika, namaskar to all the listeners. This is Attorney Shah Pirelli, and we're going to have Shah Pirelli Law Show today, talking about, of course, immigration law. And I have with me on the board my good friend Michael. Hello, Michael. I hope you're doing well, and everybody's doing well there. We are live on air right now on Radio Zindagi and KLOK 1170 AM. And of course, we're going to talk about immigration law. And if you have any questions, the number to the studio today is 510-657-1170. 510-657-1170. But we're not going to take the course right now. We have some other things to finish. We are going to talk. Of course, before I start, I'm going to repeat that anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. I don't know if the message got in, so I had to repeat it. So now we're going to talk a little bit about what's happening, of course, on immigration law. A lot of things are happening. As you know, we have all those parents who supposedly are supposed to be united with their children at the border, and unfortunately not all of them have been reunited, and and that's kind of sad. One of the children died, and that was kind of heartbreaking when I heard the news. And a federal judge has requested that all those children be reunited with their parents, and now there are a bunch of lawsuits coming up. There are also some news that some people are actually going to file a lawsuit to request that the spouses of the applicants for I-140 from India and China not to be counted towards the quota. If that happens, we're going to see, if the lawsuit goes through, we are going to see a good chance that things are going to be changing. We will have a less waiting time, and we are hoping this will go through, and that instead of having 20 years of waiting time, maybe an EB2, etc., it will be reduced to less time than that. I think we have some callers, right, Michael? Let me take the callers. Is Suresh? Hello? Hi, Suresh.
Hi, Shah. Good morning.
Hi. Good morning. How are you?
Good. Shah, so I have a question on the EAD renewal. I just applied for the renewal, but if I don't receive soon, how long can I continue to work without the renewed EAD?
Okay, what EAD did you apply? The pending adjustment of status, H4E?
Yeah,
what kind of
pending adjustment of status, GC.
On the receipt, it should say 180 days. Does it say that?
I haven't yet received the receipt, but I have applied it. I still have to receive the receipt.
Usually for adjustment of status, they give you 180 days to continue working until it's approved. So check on the receipt if you see that. When is this one expiring?
In December.
In December. Okay, so you just applied then. No, it's too early to apply right now. So usually
180 days before we can apply that. Right?
Well, they say 180, but usually the law is 120 days. So you can apply earlier, but sometimes if they become strict, then they might not give you. The rule for EAD is usually 120 days, although many people are able to apply within 180 days. So apply early, but don't wait the last minute. And the way it works is that once you apply, usually when you apply for EAD based on adjustment of status, they give you another 180 days from the date of the application. and from there you can continue working until it's approved. And if it is approved before that,
it's not from the date of expiry. It's from the date of application. Is that they give the number of days?
Usually it's from the date of the application. I don't remember exactly because it's been a long time. I didn't handle that part. But I think it's from the date of the application, not from the date of the expiry, because the 180 starts running. But it should be from the date of the expiry. I have to double check on that. It's been a long time. I didn't look. You will see it on the receipt. But I will double check on that and give me a call at the office. I'll confirm with you because it doesn't make sense really to do it from the date of filing. It should be from the date of expiry. But as far as I know, this is a new rule, by the way. So I never had this issue because most of those cases get approved beforehand. But I'll double check and then I'll let you know. Okay?
But I can apply right now, right? Is that okay to apply?
Right now, yeah, you are within the 6 months, so 180 days. Yes, you can apply now. But the rule is usually 120 days. But I know a lot of people apply within 180 days. They still accept it. Okay.
Okay. Thank you.
Good luck to you. I'll double check on that because I never really kind of paid attention. I usually say 180 days. I never checked if it starts from the date of that. So I'm sorry for that. I'll double check and I'll let you know. Okay?
Okay. Thank you.
Okay. Good luck to you. Let me take another caller. Hello. Can I speak to Vijay?
Hi. Thanks for taking my call.
You're welcome, sir. Go ahead.
So I have two questions basically. So one is my employer, my date is going to be current. I am on EB3 category. It is going to be current in a month or two. So my employer is saying that they cannot take care of that. Like you have to either file yourself or hire an attorney.
Yes, that's fine.
So
hire you.
I just Googled it and what documents I need. I think I got Supplement J and employment confirmation letter. So that is my first question. Second question is I asked your office, Newark office, for an in-person consultation with you. They are saying that till December you cannot have an in-person consultation.
Yeah, I'm not taking because I'm traveling a lot recently and I'm on and off. So I'm not doing in-person consultation at all until the next 6 months because I'm so overwhelmed with work. The only consultation I'm doing is on the phone. So if you want, you can just call us and I can talk to you on the phone. That's not a problem. Okay? But if you want us to handle it, there's nothing. Just to let you know, even in the consultation, I don't give the checklist because the checklist is usually given once you have our office handle your case. So the only thing that I can guide you is Hello. I think you have let me take another caller because I think I have a background. Hello. Hi,
Hello.
Hello, hi. This is Shah. You're live on air.
Hey, hi. This is Lucky from Tampa. And
hi, Rajesh.
How are you?
I'm doing well, sir. I'm doing well. What can I do for you?
Thanks for taking my call. And I do have a question regarding successor and interest. And I'm on H-1B. Recently got approved until 2021, and I have an approved I-140. But last month, my company has been bought by another company, and I am not right now filing my H-1B amendment. And I have a question. What if I want to change my job? Can a company file a H-1B transfer without amendment?
Okay, let me get it right. You're with company A, and company A has been acquired by company B, and you want to move to company C, right?
Yes, sir.
Okay. Well, you need to know if it is a full successor in interest. That means, was it absorbed completely as is? Did company A absorb company B as is? Or there was some changes?
Okay. Yes, because company
there's
B,
nothing.
Okay, company B has a lawyer, and their lawyer told me that it's a successor in interest, but they are not filing H-1B amendment as of today.
Yeah, they don't have to file it if it is a full successor of interest. They have to file an amendment if you change location and things like that, but if it is a full successor in interest, there's nothing to do. You just they absorb the H-1B the way it is.
So if there's I'm sorry, go ahead.
Yeah, there's no material change according to them under successor in interest. But you have to make sure it's a full successor in interest, which is the case probably because your lawyer is telling you that.
Yes, but my question is, now I'm going to move to company C. So when I will submit my paychecks for company for H-1B transfer, the paychecks are coming from company B.
Yeah, then they have to explain. Your company C lawyer will have to explain that there was a merger or an acquisition by company B, which took over, and that's why the check stub is coming from there, and explain the successor in interest in the application. That's fine.
Oh, okay. So in that terms, press release from the company, like press release document from the company will work, correct?
It all depends. I don't have enough facts to tell you, but yes, it should, as long as, because the details of the successor in interest is what is important. So that is very hard for me to tell. I will recommend checking with the lawyer if you can get more information. But if they are telling you it's a successor in interest, then it is. You can use the press release, and hopefully it will be enough. But I cannot really tell because those are internal documents. And I'm pretty sure if it is a big company, it will be known, so it should not be a problem.
Oh, okay. Yep. Thank you. Thank you very much, Shah. Thanks for the
good luck to you. Good luck to you. Yeah.
Thanks,
so I don't think we have more callers, right, Michael? So feel free to call 510-657-1170. 510-657-1170. I think we have another call. Santosh. Hello. Hello.
Hello.
Hello. Yes, sir. Go ahead.
Your voice is pretty low. Hello.
Hello. Yeah. Some of the calls, I don't know. It just does that.
I can't hear. I can barely hear you. I can't hear you at all.
Can you hear me now? Can you call again?
It is very extremely low.
But I can hear you properly.
Okay. Okay. So let me try to ask the question then.
Okay.
So I'm planning on to do green cards for my parents. I am a U.S. citizen. So I had a question that do we have to file 2 I-130 forms, one for my dad or one for my mom, or do I have to just file 1 I-130 form?
2, one for your mom and one for your dad.
Okay. So if there are 2 I-130 applications, so my follow-on question is that, so do I have to then also file 2 I-864 forms or just 1?
2. Everything 2.
So the I-864 form is also 2?
Yes.
Okay. Just my last question is that, so they're asking for marriage certificate for my parents.
Mm-hmm.
So if I don't have the marriage if they don't have the marriage certificate, is there a workaround, or how can we go about it?
Mm-hmm. You need to get affidavit of marriage. So you need to get 2 people who assisted the marriage sign an affidavit that they attended the marriage and they know they were married. Just like affidavit of birth, you have to do affidavit of marriage.
Okay. Actually, I could barely hear you there. Can you just repeat that if you don't mind?
You will need affidavit of marriage.
Mm-hmm.
2 affidavits of marriage for each. For 2 affidavit of marriage, you can use the same. So you need 2 people to sign on that to say that they were married on so-and-so date and they testify to that.
So then that will be accepted by the USCIS?
Well, that's what they accept, yes, of course. I do that all the time.
Okay, got it. Okay.
Okay? But it has to be done properly, okay? Don't make mistakes on those. Otherwise, they will reject the case, okay? And if you need help, just give us a call, 510-742-5887, okay? Good luck, Santosh.
Thank you.
So I don't know. You're welcome. Michael, I don't know. We are having some Sometimes it seems when people call from some kind of phone, we have this issue of the sound. So I don't know how to fix that, but hopefully we don't have the problem in the future. And the number, the studio today is 510-657-1170. 510-657-1170. And this is Attorney Shaparali from the Shaparali Law Group, and we are talking about immigration law, of course. And we have been talking about in the beginning about some issues that we are seeing, but I'm just going to kind of go over the things that have been happening the past few weeks. One of them, of course.
Sure, excuse me. We have a call waiting for you. Okay,
Okay, let me take the next caller.
Go ahead.
This is Shaparali live on air. Hello.
Hey, hi. My name is Vaibhav, and this is regarding my H1 extension. So I have applied for the extension in November 2017, and I have not received an RFE, but still it's almost past 8 months. It is in Vermont office. So I just wanted to check, is this anything I need to escalate to attorney or company, or how can you guide on this?
Well, if you have reached 8 months, is it a transfer or an extension you're saying?
It is an extension.
Yeah, so that means you're technically not allowed to continue working after that. So I will recommend premium the case now at this point. Because if you don't premium it, then you stop working.
Yeah, so actually my visa expiry date was in March, but I applied in November.
You applied in November. But still, it's they don't give you 240 days from the expiry. It's from the date of application. So, but I will still recommend that you file a premium now at this point. It's been too long.
Okay, so it's actually completed in March end. So it's just like April, May, and June. So it's just 3 months, 4 months, July. So it's basically 120 days now currently.
Filed it for so many months. So if it gets denied now, what will happen to you is you will be out of status, and then if they apply the memo of notice to appear, you might get placed into deportation. So I would recommend filing. Well, at this point, it's not going to make a big difference you file it or not, but I highly recommend it. 8 months is too long. You should get an answer. Usually the average time is 6 months to 7 months. So 8 months is a little bit too long to wait. Okay?
Okay, thank you. I will approach my attorney and get premium. Thank you.
Before you do premium, I recommend that you have your attorney try to contact them, or the company try to contact them and check what's going on. Then if that doesn't work, then go for premium. Okay?
Okay, thank you so much. Thanks.
Good.
Bye.
Let's take another call. Hello.
Hello.
Hi, Sapna. How are you?
Yeah, I'm doing good. Is it Mr. Shah?
Yeah, this is Shaparali. How are you?
Yeah. Hello, sir. I'm not able to hear you clearly.
Yeah, we're having some issues today on the phone, I think. But can you hear me now?
Slightly. It's in a lower voice. It's okay.
Okay, ask your question, and then you can hang up, and then I'll give you the answer off air. And then you can listen on the radio.
I didn't hear you, sorry.
Oh, okay. Ask your question off air, and then... Hello?
Hello. Can I go ahead and ask my question? Can you hear me?
Yeah, I can hear you. Go ahead.
Okay. So, yeah, this is regarding my friend. One of my friends, he has applied for H1B extension in September 2000. And he received RFE after 245 days.
Mm-hmm.
And he's still here and working and trying to respond to RFE.
Mm-hmm.
Now he came to know that he shouldn't work after 240 days.
Yes.
So can you please let me know what options does he have now and how should he proceed?
Well, he needs to... Did he file premium already? No.
No, he did not apply in premium.
Okay.
That was the stage in September 2017. He could not apply for premium.
Okay. So
but
what he needs to do...
in March, he got RFE.
Is there an RFE or no?
He got an RFE.
Okay. Okay, so technically they're supposed, if they have not answered the RFE yet, they have to answer the RFE, otherwise nothing is going to work. But usually they advise on their memos with AILA that once you reach 200 days, you have to call and start pushing it. In his case, if this was not done, I recommend now to premium the case because the RFE is already there. Premium the case and stop working.
Start the premium case again.
Yes.
You want him to start the premium case again. Okay.
Yeah.
And so he can continue working, or can he stay here?
Well,
sorry,
he can stay, but he cannot work.
He cannot work, he can stay.
Yeah, but it becomes a problem then, because if he stays also and then the case gets denied or he has some issues, it will be a problem, the H-1B itself. That's why when you reach 200 days, you're supposed to kind of start pushing for it. So there's no other options right now. He can stay as long as the case is pending, but he cannot work, okay?
He cannot work, but he need to start applying the premium process immediately. That's
the
solution.
only way. They're kind of being really, now everything has to be applied on premium because waiting on that is now there's a denial with all the complications. It's not recommended just to keep it on normal processing. Okay?
Okay. I was not able to hear you clearly. It's
okay.
I think I got
I'm
few
so
of
sorry
my
we're
questions.
having some issues. But give us a call, 510-742-5887, and we can talk.
Which was mentioned on your website, right?
Yes.
I'll
okay. Good luck.
Yeah, I'll try to reach that number.
Okay, take care.
Yeah, thank you. Thanks for answering my call. Bye-bye.
You're welcome. Yes, I'm so sorry we're having some technical issues, so let me take another caller. This is Sharif. You're live on air. Hello? 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 What? Hello? This is Sharif. You're live on air.
Hey, Shah, this is Akshay here. Shah, I have a question for you regarding the H1 amendment. So with the change in the roles and responsibility in an organization and with the promotion in the organization, is it a good idea to file an amendment on H1 like from level 1 to level 3 or 2, something like that? Or at the current moment, the way the current environment is going on, it is not a good idea because a lot of rejections are coming up even with the amendments also.
Okay, I'm sorry, I didn't hear you properly. Can you just repeat?
Sure. So I have a question with respect to the H1 amendments. So right now, in the current scenario, we are hearing so many rejections coming up for the H1 amendments in the same organization. So if someone is getting a promotion or his roles and duties are getting changed, he is promoted to the higher senior role, is it a good idea to file an amendment for the H1, or is it okay to continue with the same H1?
It depends if it is a material change. The rule for amendment is the Silmi case. If it is a material change, you're changing from a completely different position, yes, you will have to file an amendment. So,
what does it mean that material change as it?
Well, that's why it gets tricky. Material change, it has to be material at least. Well, I don't want to give a percentage, but we have to look at the entire case and see if there was some. For example, let's say you're a software engineer and now you're becoming a manager or something, then it's a change. You will have to amend it. So it depends. If it is just a little tweak or here and there, you might be okay. But I recommend doing the amendment just to be on the safe side.
But changing to like title of a manager and the H1, is it safe to do it? Because H1 most of the time they said it's better for the technical specialist or you have to be a technical like more of the technology person, like expert in some technology. Is it a good idea to move on the managerial role as well?
Well, it all depends. A manager can also be doing technical work. But yes, if you're going in purely administrative job, then you're kind of stuck. So I will recommend that you don't take this kind of chance. So I I will just tell you, we need to look at the entire case. Make sure that if you're doing any kind of above 50% of change, I recommend doing an amendment. But anyway, even less than that, I will still recommend doing an amendment. Okay?
Okay, and how about will it impact the green card process as well? Like if the green card process is is going on, if an organization just started with the filing of green card?
Because if you're getting promoted, you're pretty much kind of in a situation that previous job is no longer available. So you need to make sure there's an amendment. Okay?
Okay, sure. Thank you.
Okay. Good luck to you. I think I have Sharif on the line, right, Michael? So I just wanted to quickly, before I take Sharif, I just want to let people know that I have attorney Sharif who works in our office. He's an attorney who handles our office in Washington, but now he's here in the Bay Area, and he has been doing very, very well with our EB cases. So, Sharif, are you there?
Yeah, hi, Attorney Shah. How are you?
I'm doing well, Sharif. Thank you so much for being on the phone with me. So congratulations on all the win on all those cases. So I wanted to check with you. Tell us a little bit what's going on the EB1 and national trust waiver cases, and so that we can kind of look into the possibilities.
Sure. I think I'd like to just, again, talk first about EB1A because that's the one that has been, I think on fire in our firm and the one that I've focused on, and we've had unbelievable success this year. It's been just amazing in terms of how many people have been approved and changed their life dramatically from an area where they're in total desperation of not knowing, what's going to happen to, getting the green card. So that's obviously something that we're extremely proud of and couldn't do without your guidance and support. So I thank you as well. So in terms of EB1A, I think that folks need to understand that you cannot only look at the 10 criteria that are listed on the USCIS website and say, okay, I need a minimum of 3, therefore I qualify or I don't qualify, and that's how I'm going to approach it. Because this sort of approach is I think, giving up on a lot of effort that could be utilized. Because if you look at the statutory requirements regarding EB1A, it's a situation where there are actually 3 requirements. The first is that they need to demonstrate they'll prospectively benefit the U.S., that they're going to bring about future benefit to the U.S. The second criteria is, or requirement is that they demonstrate that they have sustained a claim recognized in the field of endeavor. And then the third requirement is that they will continue to work in the field of endeavor. So when we talk about the 10 criteria that folks are familiar with, whether they have awards, whether they have scholarly articles, whether they have, original contribution of major significance, whether they have worked in a critical role for an organization that has a distinguished reputation, whether they are members of a professional organization that requires outstanding achievement of its members, all of these criteria are only dealing with one slice of the overall requirement, which is sustained a claim. But if you want to really break it down further, we look at sustained a claim in terms of what exactly the statute says. It says that the person needs to demonstrate that they have sustained a claim recognized in the field of endeavor. So to me, this is all about 2 things. One, recognition, and the other thing, and what I hope we could talk about a little bit, is field of endeavor. Oh, God, how important field of endeavor is. I mean, if, for example, I hear it all the time, I had a client a couple months ago come in and said, I asked them, what's your field? They said, I'm a software engineer. I said, okay, but what's your field? They said, oh, software. Okay, but what's your field? Applications. What's your field? And then finally, after asking them 5 times, they tell me their field relates to application development for, a particular kind of medical device. Now we're talking, because we could position you as a person who's an expert at developing applications for a particular medical device. Narrowing the field of endeavor is the first and most important thing anybody needs to do if they're thinking about EB1A. You cannot be a very broad field, like my field is education, my field is marketing. No, it has to be very, very specific and narrow, because the ultimate test of EB1A is not whether you meet 3 of 10 criteria. It's whether you have risen to the very top percentage of your field of endeavor. So how do you do that? You narrow the field. When you narrow the field, rising to the very top is much, much easier. Think about like, when you have water or something, when you squeeze it, right? When you narrow it, everything pops out, right? So how do you rise to the very top is to narrow your field of endeavor. That's really my number one advice to people thinking about this criteria.
Exactly. So to put it in simple terms, this is where we are getting it right and we are getting such a high success is because we are going back to the law, to the source, instead of relying on secondary information like the situations where we're basically looking at, people tend to look at things with a checklist, and we don't go by the checklist, although we use that as guidance. We go deep into it and fight it, and that's what we have been doing with most cases, and that's where many other people are failing because they are just sticking to those points. And
exactly.
I wanted to congratulate you. I think so far we have almost 100% success rate when it comes to all those cases. And I'm very, very proud of that because once we analyze it and we find that little thing that makes the case, we have been able to do it. And so far we have been processing, I don't know how many, I think per month we process, I think maybe almost so far, well, I don't want to count it, but we've done a lot of them and we have a lot of people who are very happy. I have people personally I know for years who have never dared, and one of them recently, a good friend now, he became a good friend because I've been working on his case for years. Finally, he decided to go an EB1, and he got approved within 2-3 weeks, right? After
now he's going to be even a better friend.
Yeah, well, amazing. I'm very, very happy for him, and he was very happy, and he's been waiting for years, and now using that priority date, we were able to get him adjustment of status could be filed. So all those things are possible, and people miss it because they always thought that EB1 are for really like those top 5%. It is for the top 5%, but it depends where you position yourself, as you said, and this is very important. Tell us a little bit about some examples of cases where basically, without, of course, giving confidentiality, some issues where people get it wrong and where we can correct and we can handle it. And also just to let people know the way EB1 works, we are talking about EB1A here, it's more like an artist's work, right? So it's not like you plug in the documents, it will work. No, that writing is what the secret in those, just like they say for KFC, it's the secret in the spices. This is where our secret lies in putting those paperwork together and writing that cover letter and that petitioner's letter. So tell us a little bit about this and also about EB1. Because EB1A, the great thing, you don't need an employer to file, so a lot of people don't take advantage of that. Tell us, Sharif, what they can do, and then they can contact us, of course, 510-742-5887. Tell us a little bit more.
Sure. So, of course, you can self-petition, and that's one of the beauties of EB1A. What I do want to share with you is in terms of thinking about things like a checklist and having, these are the documents we need in order for you to qualify for EB1A. I think what's special about what we're doing at Shaw Pearley Law Group is we're giving people a customized approach. And I think that's what's making the difference with a lot of these cases. I actually had a call this morning with, someone who's coming on board, and they said, are you going to send me the checklist, Sharif? And I said, look, I can send you a checklist, but honestly, I want you to totally ignore the checklist, and I don't really care about the checklist. What I want is for us to have a roadmap call where we work with each other, have a shared electronic document folder where we work together and develop a very customized approach that suits your individual needs. Because every case is going to be very, very different, and every case is going to require individualized attention. So how we develop the case, some people maybe, have publications and specific review work, and some people work in fields, and these are, of course, my favorites, where it has nothing to do with publishing work. It has something to do with making money. So to me, I think that the folks that are out there, if you're in the $200,000 range, honestly, I want to talk to you because I think I could get you approved. Because I think that right there, you find a way to rise above your pay grade, above the other members in the field. I mean, think about what the average income is in the United States of America. And I have folks who make $250,000, $280,000 a year working in, whether it's Silicon Valley or biotech or any kind of industry, and they just think that it's normal. It's not normal. You are in an extraordinary situation. To me, that salary, when we talk about recognition, if you're in those kind of figures, what more recognition is there than the fact that somebody's paying you close to $250,000?
Exactly.
I can't see it.
People are a little bit, we have been stuck in that kind of dogma, I'll call it, quote unquote, of the way to do things on EB1. And even me, I was kind of stuck in it until you came in the picture and we started discussing about an alternative way to deal with EB1, and it worked. And it is working, and it's working on a daily basis now for us. And I will encourage people to give us a call. If, like you said, if you're making good money like that, above $200,000, this is not the normal salary in the U.S. So people think, well, that's normal in your industry just because you're hanging out with people from the Silicon Valley, but that's right there a proof that you are of ability. So that doesn't mean, of course, all the people will qualify, but at least we know now where you stand. And if you're making that kind of money, there is a chance you do qualify. So give us a call, 510-742-5887. The other interesting one that people don't look into, Sharif, EB1B, of course, that's one required employer, but the national interest waiver, because although people don't, especially our listeners are from India, but we also have listeners from all over the world, national interest waiver is an EB2 category, and it doesn't require an employer. And the good news about this is that doesn't require an employer. You don't need a labor certification. And plus, at the end of the day, if you're moving around, that I-140 stays with you, and you can use that any time when the dates become current. So people who do qualify for that, tell us a little bit about those. I know we're doing a lot more EB1A than national interest waiver, but if you could just talk a little bit about that, how do you approach the national interest waiver?
Sure. And another point about national interest waiver, too, is that a lot of the information that's available online, just like in the case with EB1A, is outdated. And, it's just been there so long and has so many clicks that it always rises to the top. So when people are searching national interest waiver, it's very easy to be misguided. So I really encourage everybody to schedule consultations, speak with an experienced attorney, have somebody really look at your case and analyze whether or not you meet that situation. So here, when we're talking about national interest waiver, we have to look at the Donisar case. The Donisar case is a case that set the legal standard for national interest waiver, and where you need to basically demonstrate that the work that you're involved in has both substantial merit and national importance. So what that means is folks that are working in important fields that have an impact, especially if we're talking about human health, human lives, but if we, medical, biotech, people that are doing like drug development, medical devices, things like that, definitely national interest waiver written all over it. I think it's relatively straightforward to get approved in those in EB2 NIW, and that way you're not so dependent on your employer to sponsor you for your EB2. The second requirement is that you personally are well positioned to advance the proposed endeavor. So, for example, I work in biotech. I'm, doing something that's really important. I'm working on, drug development for, certain types of, medicines. And I myself have experience in the field. I myself am well educated in the field. I myself have a track record of success in the field. Now I've demonstrated that I'm well positioned to advance the proposed endeavor. And this isn't limited to biotech. You could do it in many other facets of industry. The third requirement is that basically we justify the reason for you not getting a labor certification. So that on balance, it'll be beneficial to the U.S. to waive the requirement for you to go get your labor done. And this is basically fits in with the other two criteria, but one approach that I've used here that has been successful is to show that there are opportunities for the applicant from companies or institutions that, as a matter of policy, do not sponsor foreign workers. For example, certain states, like state agencies, have a policy that we do not sponsor foreign workers. However, this person, their profile fits exactly with what that state agency needs. Therefore, on balance, it gives you a reason why the labor certificate is not needed or should not be required for this particular individual. So, and there's a lot of other ways to do that, but that's basically the situation. Just to recap, you work in an area that is important, has substantial merit to it, right? And this could also be folks that are in the business world that are, if you're making, economic benefit for others or creating, efficient processes, that could also be substantial merit. It doesn't only have to be medical, but medical is obviously a easy one. Again, you are personally in a position to advance that cause, and lastly, that you, on balance, it's beneficial for them to waive the labor certification requirement.
Yes, Sharif. So we're almost kind of done with the show, so we have 2 minutes to go. I just wanted you to kind of recap. We do also L1A, L1B, which are very related to the EB1C. Quickly tell us about EB1C, and then we would have to kind of close the show today. But thank you so much for calling today and to kind of give us an update what's going on the EB1. Just to remind people, we're talking about EB1A and also about national interest waiver. So, Sharif, I'll give you like 2 minutes to recap, and then I'll close the show. Go ahead.
Okay, just in terms of if the EB1A category is not an option for you, and you've looked at national interest waiver and you say, you know what, I already have an EB2, I don't really need national interest waiver, and I'm just really sick of my situation in terms of having to remain on H-1B and over again. The other option obviously there is EB1C, and whether if you work in a managerial or executive level, what you could do is you could look at opportunities. Either you have already performed in that managerial or executive situation overseas, or you look at opportunities overseas from a company that has a U.S. entity and also an entity overseas. So, for example, if there's a company that exists in the U.S. and they also have a subsidiary company in your home country, maybe you could seek a managerial executive position at that subsidiary, work there for a period of time, and then see whether there's an opportunity to come back in the United States. And in that case, you may qualify for an EB1C situation. Other ones I've seen is if you already have an organization overseas that you've done work for, that you have developed. But this, I think, is a little bit complex and could be worked out. But strategic planning in advance is really, really important. And just thinking through exactly what all of your options are is something that you really, really want to do. So again, EB1C is there for folks. If you have, for example, for our listeners that are overseas, if you have a business, if you're already in business and your company is interested in opening a new office in the United States, we can talk about starting with an L1 visa where you open a new branch office in the United States, operate the business for a couple of years, a year or more, depending on how successful it is, and then, seeking an EB1C situation as well. So, because one of the requirements is that the business has to exist in the U.S. for more than 1 year. And the other one, of course, is that you've worked a minimum of one of the past 3 years in an overseas branch, or at least one of the 3 years preceding entry to the United States.
Yes, indeed, Sharif. So I just wanted to let people know we had, this is Attorney Sharif from the Chaparral Law Group. Also, Sharif is with us working on, especially kind of in charge of the Department of EB1, because now we have so many cases, we had to set up a separate department. And thank you, Sharif, for calling from Washington today. And you can check online. We have a lot of those reviews, etc., how we have done EB1As. And if you want an assessment, if you do qualify, or even if you just feel you qualify, give us a call, 510-742-5887. And Sharif, I just wanted to check with you, for those people who are, what kind of, usually we get their resume, and then if they email it to us, and also their link, maybe their LinkedIn. But even that is not enough until they do a consultation, at least to go over things, because a lot of times they don't put things that we need on those resumes, And until we ask the question, like you said, 2-3 times, then we get the exact picture where that person stands. And that's why we need you to talk to us in order to get things moving. So what will be your quick advice, Sharif? You have 30 seconds to do that.
Yeah, I think with 30 seconds, I'll repeat just again that the individuals that are in jobs that are creating economic activity, like really generating big money, or that you yourself have been assigned a really high salary, it's not just because there is one criteria under sustained a claim that says commands a high salary. The point of this is it means you have recognition in your field. If Sharif is basically making, $20,000 a year, and that's publicly known, I don't think anybody's going to have much confidence that he's going to be able to handle really complex immigration, matters, with all due respect to people that make that kind of money. But if they know that he's, this guy's, a big, person in this field, he's making huge amounts of money, it's probably for a reason, right? So that's what recognition is all about. I mean, it's brutal, but it's the reality. And it really, really matters. So I'm sorry to put it that way, but that's the reality.
I think they just told me we have another 5 minutes to go, so I would like to take advantage since I have you on the line. So tell me, Sharif, we have all those cases that are coming to us, and we're getting people all over the world. Lately I had a client just call us from Romania. We have people from Pakistan, Bangladesh, Europe, and I know for India there is this backlog, and most of our clients are from India. So people are a little bit scared to file the EB-1. But what would you tell them? What will you tell them if they are worried about filing an EB-1? Just to let people know, EB-1 doesn't affect your other categories. So if you have an EB-2 is running, this stays alive while you're filing the EB-1. So tell us a little bit so that, because people are very fearful. So tell us, we have 4 minutes to go. So please tell us what would you kind of tips you will give them if they feel like they should move forward. Because
I think the number one tip I would do is to get an assessment. I mean, you really need to have someone look at your profile and think through these things with you and talk to you about strategy and whether or not a pathway exists. Because a lot of folks think that if I don't have the documents ready to send to an attorney, then there's no attorney that's going to waste his time on me. Unfortunately, that's another reality that we have. So, there's so many attorneys that are paper pusher in terms of send me all the documents, I'll organize it and send it to, the immigration service, whereas a different approach might be let's go hand in hand, talk about what the requirements are, talk about what the statute is, talk about what exactly we need to do in order to meet those statutory requirements, and then work with you to dig out of your history, to dig out of your profile, to just, kind of get everything, milk everything from your career, from your work history, from your education history, from everything that you've ever done up until this point, position you to be at that level of an individual that's going to meet the statutory requirement. That may take a process that may take several months. So if you're in a rush and you have anxiety and I have to submit this case now, honestly, you're probably going to hurt yourself. But if you position yourself in a situation where I can work strategically with somebody that knows what they're doing, we work over a period of time, we develop a case to the point where it is then approvable, you could be in business. And I think ultimately that's really the best approach.
And exactly, Sharif. So I'm going to let you go, Sharif. Thank you so much for putting this together. Bottom line, I just wanted to let people know what Sharif is talking about here is in simple terms, is we are going back to the source. We are not taking secondary checklists that you see even on the USCIS website. It's it's not disinformation, but it's kind of not really the law. What they did, they tried to simplify it, and by doing so, they have created a criteria that is not really required to get that. Although we use it as a guideline, but this is not what we are looking at. What we are looking at is if you are outstanding and if you have done something extraordinary, and for example, the salary, like like Sharif is mentioning. That's what we're looking for, and we are good at this. And like I said, it's an artistic work. It's like not everybody can paint a picture, and with Sharif and I, we see things in a different manner, and then that's why we have been able to come up. And hats off to Sharif on that. He really kind of brought it home on this, and I wanted to thank him officially. The high success rate is amazing, and we are not here making up things. It's the truth, and they can check our online reviews, etc. So, ladies and gentlemen, Sharif, I'll let you go. Thank you so much, Sharif, and hopefully I'll get you in a couple of weeks more to talk a little bit more about other success stories. Thank you.
Thank you so much. I appreciate the opportunity. Take care, guys.
Thank you so much. So, ladies and gentlemen, now we're going to close the show, and before I close, just wanted to let you know anything we told you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And before I close, I know I couldn't take more callers today because of the situation, and I apologize for that. Feel free to call our office for a consultation, 510-742-5887. We'll be glad to help you. Another thing which is another areas we practice in is debt settlement happening. Since we are very busy, the best way to communicate kind of in terms of giving information is the YouTube channel. Please subscribe to it, youtube.com/sharp-rally-law, youtube.com/sharp-rally-law. Please check it, and if you need any help, 510-742-5887. Thank you so much, ladies and gentlemen. Thank you, Michael, for helping. And again, all information I've given you today is purely educational. And thank you, Sharif, for being on the show with me today. And feel free, and on Friday, the show will be playing at midnight. And check with us next week. We'll have another show. Today is August 2nd, first show of the month. Thank you so much. Bye-bye. Take care.
KLOK 1170 AM, San Jose, San Francisco, and the entire Bay Area.